This is the USA Emergency Broadcast Network, your source for reliable disaster preparedness information.
The views and opinions expressed on this program are not necessarily the views of this station, its management, sponsors, or other hosts. If you have any comments or suggestions about this program, please contact us at radio@usaebn.org. That's radio@usaebn.org.
This is American Justice 21, the show that pulls back the curtain on a justice system that promises fairness but often delivers something else entirely. I'm your host, Racheal Quinn, legal analyst, researcher, and someone who believes that justice should never depend on your income bracket. Let's be honest, most of us want to believe our laws and courts treat everyone the same. The marble floors are polished with the same shine. The judges wear identical black robes. Constitution's words are etched in stone. But under that surface, there's a divide most Americans never see unless they, or someone they love, land before a judge's bench. Two systems operate under one roof. One for the people who can afford private lawyers, and one for everyone else. Picture this: two people walk into the same courthouse, both accused of similar crimes. They'll sit on the same hard benches, wait under the same fluorescent lights, and hear the same call, "All rise." But the moment the clerk asks, "Do you have an attorney?" their futures start to diverge. If you can't afford private counsel, you're assigned a public defender, someone who might be responsible for 200, 300, sometimes even 400 cases a year. That's hundreds of lives to juggle, hundreds of stories to remember, hundreds of families counting on the same exhausted advocate. If you can afford a private attorney, you step into a world where time, strategy, resources, and personal attention are standard, not luxuries. This isn't just a difference in comfort or convenience. That divide doesn't just shape what happens in the courtroom. It shapes your bail, your plea deal, your trial, and the trajectory of your life afterward. It can determine whether you spend months waiting in jail before your case is heard, or whether you walk out the same day on your own recognizance. Can decide whether you feel pressured to plead guilty to something you didn't do simply because you can't afford to wait and fight. Today, we're diving deep into how these two systems really work, what the real consequences are, and why the difference between a public defender and a private attorney is much more than a matter of price tag. It's a matter of power, access, and sometimes even freedom. More importantly, we'll break down what you can do to protect yourself and the people you care about long before you ever see the inside of a courtroom. We'll talk about the choices that matter, the resources you should know about, and the policy changes that could level the playing field for everyone. So, whether you're tuning in because you care about justice, because you want to be informed, or because you or someone you know might one day face these questions, stay with us. This is a conversation about rights, reality, and how we can push for a system that lives up to its promise, for all of us. Let's start with the uncomfortable truth. Justice is supposed to be blind, but in practice it sees your wallet very clearly. Where the divide begins. The right to an attorney is enshrined in the Sixth Amendment, a cornerstone of American justice that, in theory, should guarantee everyone a fair shot in court. But in practice, what that right looks like can be wildly different depending on the system you enter. The reality is shaped not just by constitutional ideals but by the size of public defender budgets, the number of attorneys on staff, and how much local and state governments are willing to invest in indigent defense. In nearly every jurisdiction, public defense systems are stretched thin. Offices face chronic underfunding, political battles over resources, and crushing caseloads that force defenders to juggle hundreds of clients at once. Private attorneys, by contrast, set their own workloads, and typically have far fewer cases at any given time, allowing for deeper preparation and individualized strategy. This gap shows itself right at the door of the courthouse in the very first critical moment, the bail hearing. Bail isn't just a procedural step. It's often the moment that determines whether a person will fight their case from home or from behind bars. The difference in representation becomes unmistakable here. A private attorney steps into court with an arsenal of preparation. They arrive with employment records that demonstrate a steady job, community ties that show roots and responsibilities, and proof of stability, like rental agreements or family affidavits. Before the hearing, they've already crafted a detailed bail argument tailored to the judge and the facts. They're ready to advocate for their client's release, counter any prosecution claims, and suggest alternatives to cash bail if needed. Employment records, sometimes letters from employers promising continued work. Community ties, evidence of local family, property, or long-term residence. Proof of stability, documentation showing the client is not a flight risk. A bail argument, often supported by legal research and knowledge of local practices. But for those assigned a public defender, the story is very different. Public defenders often meet their clients for the first time just moments before the hearing, sometimes in the noisy hallway outside the courtroom. They rarely have advance access to documents or witnesses. With little time and almost no leverage, they do their best to make the strongest argument they can, but the odds are stacked against them. In many cases, they must address the judge with only minimal background on their client's life or circumstances, and no time to hunt down supporting evidence. Consequences of this imbalance play out in statistics that are hard to ignore. According to the subject report, research reveals that Black defendants face bail amounts up to 35% higher than white defendants charged with similar offenses. This isn't just an abstract number. It means families struggling to scrape together bail, people held in jail for no reason other than poverty, and communities bearing the weight of unequal justice. And the attorney you have makes a measurable difference. Defendants represented by private counsel are more likely to secure lower bail, or, in some cases, walk out of court without having to pay anything at all. That early advantage can change everything. It can mean keeping your job, staying with your family, and having the freedom to work with your lawyer on building a defense, rather than fighting your case from a jail cell. What happens next? If you can't afford bail, you stay in jail. The reality is stark. While others may walk free pending trial, you're forced to wait behind bars, regardless of your innocence or the strength of your case. That waiting period isn't just a matter of inconvenience. It can stretch for days, weeks, or even months depending on court schedules and the complexity of your case. And if you stay in jail, the pressure starts building, fast. Every day spent in detention compounds the stress on your personal and professional life. You're cut off from your family, unable to work, and left to navigate the uncertainty of your legal situation from a cell. The psychological toll is immense, with anxiety, frustration, and fear mounting as time passes. Job loss becomes a real risk. Employers are rarely sympathetic to unexplained absences, and missing work can mean losing your only source of income. Family stress escalates, as loved ones struggle to cope with your absence, manage finances, and support children or dependents. The fear of losing housing grows. Without income, paying rent or a mortgage can quickly become impossible. For parents, the prospect of losing custody of their children looms large, as courts and child welfare agencies may view incarceration unfavorably. Ultimately, you face the overwhelming fear of losing everything you've worked for. Under those conditions, the idea of accepting a plea, any plea, becomes more appealing even if the evidence is weak. Promise of a quick release, even at the cost of a criminal record or harsher penalties than you deserve, can feel like the only way out. Prosecutors understand this dynamic and often leverage it to secure convictions, knowing that the longer someone remains in jail, the more likely they are to accept a deal just to regain their freedom. The system, in effect, turns the inability to pay bail into a powerful tool for pressuring defendants, especially those with limited resources, into plea agreements that may not reflect the true merits of their case. Plea bargain machine. Plea bargaining isn't a side feature of the criminal justice system. It is the system. More than 90% of cases end in plea deals, not trials. The vast majority of defendants never see a jury of their peers or have their full story heard in open court. Instead, their fate is negotiated behind closed doors, often in hurried conversations with prosecutors who hold most of the cards. But here's the critical point. The quality of your legal representation determines whether that plea is a second chance, like a reduced charge or a record that can be sealed or expunged down the line, giving you the possibility to move on with your life. A manageable outcome, perhaps probation instead of jail time, alternative sentencing like treatment programs, or an agreement that preserves your employment and housing. Or a devastating long-term sentence, a felony conviction that follows you forever, loss of rights, and years behind bars even for a first offense. Public defenders do heroic work under impossible conditions, but they don't have the time or resources to investigate every case deeply or negotiate the best possible outcomes for every client. Their caseloads can reach hundreds at a time, forcing them to triage rather than truly advocate. Prosecutors know it. They understand that many public defenders simply cannot match their preparation or persistence. And that imbalance accelerates the conveyor belt of convictions, pushing people, sometimes innocent or overcharged, to accept deals just to resolve their cases and get out of jail. Meanwhile, defendants with private attorneys often receive reduced charges because their lawyers have the bandwidth to scrutinize the evidence, challenge weak points, and push back on overcharging. Drop charges when aggressive advocacy uncovers errors, violations, or lack of proof that may otherwise go unnoticed. Diversion programs, alternatives that prioritize treatment, restitution, or community service over incarceration. More favorable sentencing agreements, including shorter sentences, split sentences, or options that avoid life-altering consequences. Because their attorneys have what matters most: time. With fewer clients and more resources, private counsel can meet with their clients regularly, investigate facts, consult with experts, and negotiate from a position of strength. They can afford to wait, push back, and say no to bad deals, knowing that every detail matters. The result is often not just a lighter punishment, but a fundamentally different experience of justice, one where the power of negotiation actually levels the field, rather than reinforcing the system's inequities. Ultimately, the prevalence of plea bargains exposes the core inequality in the system. Access to skilled, well-resourced advocacy can mean the difference between a plea that protects your future and one that destroys it. And in a world where nearly every case is resolved through negotiation, that difference is everything. What about trials? The trial is often portrayed as the beating heart of American justice, a place where every defendant's story can be heard, every piece of evidence scrutinized, and the truth ultimately revealed by a jury of peers. In theory, it's the forum where the rights guaranteed by the Constitution are put into practice, ensuring fairness, transparency, and accountability in the legal process. But in reality, the system rarely functions this way. Fewer than 10% of criminal cases ever reach trial. Most defendants never get the chance to present their case before a jury, and the majority resolve their charges through plea deals negotiated outside the courtroom. When a trial does happen, the resources available to a defendant often dictate how the process unfolds, and the difference between private counsel and public defenders couldn't be more stark. Defendants with private attorneys benefit from a full arsenal of support. Private counsel can assemble a team of dedicated investigators to uncover facts, interview witnesses, and gather evidence. They can hire expert witnesses, including forensic specialists, medical professionals, and industry experts, to challenge the prosecution's case and shed light on complex issues. Their legal teams have the capacity for deep discovery, carefully analyzing every document, surveillance video, or piece of testimony. They can file motion after motion to suppress weak or illegally obtained evidence, to challenge questionable procedures, and to ensure their clients' rights are protected at every turn. This proactive approach transforms the trial into a battleground where every detail is contested and every opportunity to defend the accused is seized. By contrast, public defenders face daunting roadblocks. In many jurisdictions, they must seek court approval just to hire an expert witness, and budget constraints often mean they're forced to make tough choices about which cases receive extra attention. Many public defender offices share a single investigator among dozens of attorneys, meaning critical evidence can slip through the cracks simply because there isn't enough manpower. Time pressures are relentless. With heavy caseloads, public defenders may have only hours to prepare for a trial that could determine the course of their client's life. Even the most dedicated attorneys are stretched thin, forced to triage rather than fully investigate and litigate each case. The result is a courtroom that, instead of leveling the playing field, amplifies the disparities of wealth and access. The place where truth is supposed to be tested becomes another arena where those who can afford robust defense stand a much better chance of a favorable outcome, while those relying on public defense must contend with systemic limitations. The outcome of a trial, and the experience of justice itself, too often hinges not on the facts or the law, but on the resources available to the defendant. This reality challenges the foundational ideals of the American justice system, raising hard questions about whether equality before the law is truly attainable for everyone. And then there's race. The report is clear and unambiguous. The intersection of race and income does not just add up, it compounds, creating layers of disadvantage that are deeply embedded in our criminal justice system. Black and Latino defendants are disproportionately represented among those who must rely on public defenders, not because of choice but because of long-standing economic disparities that limit access to private counsel. This reliance has profound consequences at every stage of the criminal process. These defendants are statistically more likely to be offered plea deals that are harsher, including higher charges, longer sentences, and fewer opportunities for diversion or expungement. The impact extends to bail as well. Black and Latino defendants routinely face higher bail amounts and are more often detained pre-trial simply because they cannot afford to pay. This pre-trial detention increases pressure to accept unfavorable plea deals just to regain freedom, regardless of actual guilt or innocence. What emerges is a stark reality. Within the same courthouse on the same day, two defendants facing identical charges can have vastly different experiences and outcomes based solely on the color of their skin and the size of their bank account. For one, private legal representation and financial resources open doors to more favorable negotiations, lower or waived bail, and alternatives to incarceration. For the other, systemic barriers and lack of resources mean navigating a process where the odds are stacked against them from the start. It is, in effect, two separate systems operating under the same roof, one where justice is negotiable and often more merciful, and another where punishment is swift, severe, and unrelenting. This duality exposes not just the flaws in legal procedure but the deeper social inequalities that shape who gets a second chance and who becomes another statistic. So what do you do with all of this? The system is unequal. How do you protect yourself before you ever end up inside it? The reality is sobering. The criminal justice system is designed in ways that often favor those with resources and connections, making it crucial to take proactive steps to safeguard your future. Understanding these disparities is the first step toward protecting yourself and your loved ones from the harsh consequences that can arise from even a minor run-in with the law. Preparation, awareness, and advocacy are essential tools for navigating a system that can be unforgiving, especially for those who lack access to private legal counsel or robust support networks. Before you ever face a courtroom, there are practical actions you can take to minimize risk and maximize your chances for a fair outcome. Gathering key documents that demonstrate stability, such as proof of employment, rental agreements, medical records, and character references, can be invaluable during bail hearings or initial proceedings. Asking your attorney thoughtful questions about the strategy, available motions, and diversion programs empowers you to be an active participant in your defense, rather than a passive observer. Leveraging community organizations and legal advocacy groups provides access to resources and support that can help counterbalance systemic disadvantages. Staying engaged with local policy discussions, supporting bail reform, and advocating for increased funding for public defenders are all ways to influence the broader system. Even small actions, like voting, attending town hall meetings, or volunteering, can help push for the transparency and fairness that everyone deserves. Ultimately, protecting yourself means not only preparing for the worst-case scenario, but also working to change the conditions that make unequal outcomes possible in the first place. 1. Prepare documentation before you need it. If you or someone you love is arrested, paperwork can literally change the outcome of a bail hearing. Proof of employment, pay stubs, employment contracts, or a verification letter from your employer can demonstrate to the court that you have a stable job and ongoing responsibilities. Rental agreements. Presenting a signed lease or mortgage document signals that you have a permanent address and are less likely to flee, helping establish ties to the community. Medical records. Documentation of ongoing treatment or health needs, like prescriptions or doctor's notes, may show the necessity of remaining out of custody to access proper care. Letters from employers or community organizations. Character references from supervisors, religious leaders, or nonprofit organizations vouch for your reliability, community involvement, and positive reputation. These documents show stability, and stability reduces bail. The more evidence you can provide of consistent employment, a fixed residence, medical obligations, and supportive relationships, the more likely you are to be granted a lower bail amount, or in some cases released on your own recognizance. Judges weigh these factors heavily because they indicate you're invested in your community and unlikely to miss court appearances. By assembling this paperwork in advance, you empower your attorney to advocate for you effectively, making a significant difference in the initial stages of the criminal process. 2. Ask your lawyer questions. Never assume you're a burden. You have the right to know. What's the strategy? Ask your attorney how they plan to approach your defense, what steps they will take, and what options you might have at each stage of the process. Understanding the overall strategy helps you stay informed and allows you to participate meaningfully in your own case. What motions will be filed? Inquire about any legal motions your lawyer intends to submit, such as requests to suppress evidence, dismiss charges, or seek bail reductions. Knowing which motions are in play gives you insight into how your defense is being constructed and what legal arguments may impact your outcome. What are the strengths and weaknesses of the case? Request a candid assessment from your attorney regarding the evidence, witness statements, and legal factors at play. By understanding both the positives and potential challenges in your case, you can better prepare for hearings, anticipate prosecution arguments, and make informed decisions about plea deals or trial. Are diversion programs available? Ask if there are diversion options such as drug treatment or rehabilitation programs, community service, or pre-trial intervention programs that could offer alternatives to traditional sentencing. These programs may help you avoid a criminal record or reduce penalties, especially for first-time offenders or minor charges. Prepared clients make life easier for public defenders, not harder. When you come to meetings with questions, documents, and a clear understanding of your situation, you empower your attorney to advocate for you more effectively. Taking an active role in your defense ensures that your rights are protected and demonstrates your commitment to achieving the best possible outcome. This collaborative approach fosters stronger communication, allows your lawyer to tailor their strategy to your unique circumstances, and ultimately increases your chances of a fair and just resolution. 3. Use community resources. Organizations like the Equal Justice Initiative, the ACLU, NACDL, and many state-level bail funds exist to level the playing field. They offer legal information, financial support, and advocacy resources that can change outcomes. These groups work tirelessly to ensure that people, regardless of their financial situation, have access to fair legal representation and support throughout the criminal justice process. For example, the Equal Justice Initiative provides free legal services to those who have been unfairly treated or cannot afford counsel, focusing on cases involving wrongful convictions, excessive punishment, and racial injustice. The American Civil Liberties Union, ACLU, fights for civil rights, offering legal assistance and challenging unjust laws in court. The National Association of Criminal Defense Lawyers, NACDL, promotes best practices among defense attorneys and educates the public about their rights, often providing guidance and training to lawyers who represent indigent clients. State and local bail funds, meanwhile, help pay bail for individuals who would otherwise be forced to remain in jail simply because they lack the financial means, thereby preventing unnecessary pretrial detention and its associated hardships. By connecting with these organizations, individuals can access a wide range of tools, from educational materials that explain their rights in the legal process to direct financial aid for bail or legal fees, to advocacy campaigns that push for systemic reforms. Many of these groups also sponsor workshops, clinics, and hotlines where people can get personalized advice and support. Whether you are facing charges yourself or supporting a loved one, utilizing these community resources can dramatically increase your chances for a fair outcome and strengthen your ability to navigate the system. Engagement with these organizations is not limited to those directly involved in legal proceedings. Community members can volunteer, participate in awareness campaigns, donate, or attend events to help build a stronger safety net for others. By doing so, you not only gain access to vital support but also contribute to broader efforts to reform the criminal justice system, making it more equitable and transparent for everyone. Engage in policy and local advocacy. Bail reform doesn't just happen in Washington. It unfolds in state capitals, at county budget hearings, and inside court administration meetings where crucial decisions are made about how justice is administered on the ground. While national policies can set the tone, real change is often driven by local leaders, advocates, and community members who push for practical solutions that address the unique challenges faced by their neighborhoods and courts. Public defenders need funding not only to handle large caseloads but also to provide effective, individualized representation for every client. Without adequate resources, even the most dedicated attorneys can be stretched too thin, impacting the quality of defense and justice served. Plea negotiations, which resolve the majority of criminal cases, must be conducted with transparency and accountability so that outcomes are fair and not unduly influenced by systemic pressure or lack of information. Sentencing disparities, where similar cases yield drastically different punishments depending on factors like race, income, or geography, demand ongoing public scrutiny and oversight. Only through vigilant examination and open dialogue can communities ensure that the system operates fairly for all. If you vote in local elections, organize within your community, or speak up at public forums and meetings, you are an essential part of the movement for change. Your involvement helps set policy priorities, holds decision-makers accountable, and amplifies the voices of those most affected by the criminal justice system. Whether you're supporting bail reform initiatives, advocating for increased funding for public defense, or calling attention to unjust sentencing practices, your actions contribute to a more transparent, equitable, and effective justice system for everyone. Justice shouldn't come with a price tag. But until the system reflects that truth, knowledge is your first line of defense. This is American Justice 21. I'm Racheal Quinn. Stay informed, stay prepared, and never stop pushing for real justice.